ليس اليتيم الذي قد مات والده، إن اليتيم يتيم العلم والأدب.
Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome, viewers. You're joining us once again on the Islamic Literary Society. And in this society, in this discussion, we'll be talking to a very special guest. And our society has been founded since 2019. And in that, we have an aim, and that is to promote and foster appreciation of authors, literary works of classical and contemporary scholarship. And I'm going to be your host today, inshallah. My name is Junaid Da. So we'll have a very thorough, fun, and informative session. We have a very special guest with us today for a number of reasons. And I'll begin the introduction. We have with us Professor Mashood A. Baderin, and he is a professor at SOAS, teaching Islamic legal theory and many other subjects. But let me give you some background. So Professor Mashood holds a diploma in Arabic, Islamic studies, which he has gained from university in Nigeria. And he was also a qualified barrister, solicitor of the Supreme Court of Nigeria, inshallah. And after some years in legal practice, he also obtained a scholarship grant for his postgraduate studies at the University of Nottingham, where he obtained his LLM in public international law, studying public international law, international humanitarian law, criminal law, international human rights, law of international organizations, and collective security law. And then, mashallah, Professor went on to obtain his PhD from the University of Nottingham, with his thesis titled Modern Muslim States Between Islamic Law and International Human Rights Law. MashaAllah, that's a lot of law. Very good. And now he is currently working in SOAS as a lecturer there, Islamic legal theory, and also teaching human rights. So I'd like to begin with a warm welcome to our guest for today. Let's bring you in. So, assalamu alaikum wa rahmatullahi wa barakatuh, Professor Mashood.
Wa alaikum assalam wa rahmatullahi wa barakatuh. Junaid, thank you so much for having me.
Okay, mashallah. And guests as well, I'll give you a little bit of secret information. Professor Mashood is actually my teacher. So
he's
my teacher. He's teaching me Islamic legal theory at SOAS in my master's in Islamic law. So it's a double privilege, alhamdulillah. Barakallahu fiqh. So also I'd like to add that Professor has authored a number of books as well. From amongst those is International Human Rights and Islamic Law, and a short book, but very powerful, useful book, Islamic Law, a very short introduction into Islamic law. And that's very important. Why? Because now Islamic law is one of the major legal systems in the world today. So there is a need to understand what exactly is Islamic law. So Professor, before we begin, how are you feeling? How are you today?
Alhamdulillah, thank Allah, we are fine. Alhamdulillah, the weather is getting colder now, but alhamdulillah, ala kulli hal. We thank Allah, we are okay.
You're probably thinking of going to Nigeria for a month or two.
Well, maybe I'm in December actually. During the long holidays, I have plans, inshallah.
Nice. Good.
You know, this is the time many people run away to hot weather.
Right. I don't blame them. So, Professor, let's go into our very first question, and that is where we left off with Islamic law. Okay, technical question, but it's okay. Let's go into it. So, Islamic law. Some may say that it is not actually law, right? Some may say it is not actually law. What would be your argument, or what would you say to such a statement?
Thank you so much. We actually do get this question from people who are in legal practice, particularly in the Western world, in the UK. You find many legal colleagues posing the question, and it's not new, really, because of the fact that the basis of Islamic law is, a religious system. It's based on religious sources, and therefore, the argument usually is that, well, it is a system of religious obligations rather than pure law per se. And many of the Western scholars who argue that, they argue it strictly from, their own perception of what law is. You know, law in the West is usually perceived in a very positive sense. You
Mm.
know, a Kelsian, what we call a Kelsian positive sense, that law, I mean, is the order, command of the sovereign, backed by sanctions. And you find that many of the issues, even though the Sharia or Islamic law does apply to worldly temporal issues,
Yeah.
but you find that, I mean, behind it is the bigger responsibility of accountability to Allah in the hereafter.
Mm.
So you find many of those things, many of the obligations, they may not have sanctions attached to them here,
Mm.
but Muslims are very conscious that there will be accountability in the hereafter.
Mm.
You know, but Western scholars, you know, they say, no, I mean, this is just an obligation to God, and therefore it's not law. But I mean, those are the theoretical aspect of it. Now, if you look at, it depends on one's theoretical connotation of law. You know, I mean, they also want to argue that, well, if anything at all, it's just a system of morals,
Mm.
teaching morality and things like that. And in the West, they want to usually differentiate between what is law and morality.
Yeah.
But the argument usually is this, you know, Islamic law is law plus because it's combined law and morality together. And that is what actually makes it, I mean, stronger in my own view. You know, so theoretically, one may argue strongly that, well, actually Islamic law is law plus, even though it's based on a religious system. There are many of the provisions, obligations that have sanctions in this world,
Mm.
and many of them in the hereafter.
Yeah.
But apart from that, if one looks at it empirically as well, empirically, I mean, Islamic law is applied as law in many Muslim majority countries.
Mm. Mm.
I mean, you see so many people being trained as, I mean, for example, me, when I finished my diploma in Arabic and Islamic studies from the university, I had to go back again to do a degree in both common law and Sharia law.
Okay.
Because Nigeria, in Nigeria, you find out that, I mean, it's a pluralist legal system where the English common law applies, Sharia Islamic law applies, and customary law. So if you want to be a grounded lawyer, we do this double major, whereby you specialize both in common law and the Sharia.
Mm.
And there are Sharia courts in many countries. You know, there are Sharia courts where the law is applied
Yeah.
practically.
Mm.
So both from a theoretical and empirical point of view, one can argue solidly that, I mean, Islamic law is law as applied law,
Mm.
you know, and it's
And that,
also, I mean, a religious system.
yeah, and Professor, that brings me to my next point, which you mentioned already, is that Islamic law, you cannot separate it from morals and ethics. So
Definitely.
from the Western perspective, they will think that as a point of weakness. But if you actually think about it, and would you agree with me? This is actually what distinguishes Islamic law, which makes it superior.
I agree totally. I agree totally. This is what makes it superior in the sense that, I mean, you have a much more powerful underlying cause that really want to motivate you to believe in the law
Mm.
and to act on it. You know, as I do say in class, you find out, I mean, it's a system of law which is applicable here, you know, but underneath it is this concept of taqwa, the fear of God. You want to do what is right. You want
Right.
to do what is morally right. You know, so I think, I mean, as you rightly mentioned, I mean, many Western scholars see that as a weakness.
Mm.
That how do you distinguish law from morality? That morality, you know, there isn't one value of morality. Therefore, it can be difficult to be able to, you know. So, but in Islam, under the Sharia, it's actually the strength of it. That's what makes it special. Islamic law has successfully combined the legal and the moral together in a way that actually strengthens the system.
Yeah. And I think as well, Professor, that as you mentioned in Nigeria and other places where you have British law being applied, but at the same time, you'll find that Muslims will go to the Sharia courts to get their cases resolved, or marriage and divorce and so on and so forth, because they need the moral and the ethical side as well as the law. So
I agree totally.
the two systems will always be in parallel. You will not be able to remove one or the other.
I agree. That's exactly the system. I mean, even here in the UK,
Yeah.
you know, we have the notion that, I mean, the Sharia does not apply formally in the UK. But the truth of the matter is, I mean, many Muslims in the UK, they conduct their affairs within their community individually. They want to follow the Sharia.
Mm.
Otherwise, people will, for example, in marriage, people could have just conducted a civil marriage and forgotten about it. But no, they only conduct the civil marriage for formality, for it to be recognized. But they will do the nikah to rest their mind that yes, this marriage is now valid under under the Sharia. So you find out that it's a system where if it is properly applied and where people really are committed to it, it's a system that is really very powerful by joining both the legal and the moral together.
Yeah, absolutely, absolutely. And as an imam, and also you're an imam as well, we find ourselves very busy with conducting nikahs and trying to resolve marriage disputes, all under the guidelines of Islamic law.
Exactly. People have questions all the time. Not only marriage, even wills, in relation. Actually, somebody came to my office, at SOAS. They emailed me, and a very committed Muslim sister emailed me. They indicated that, well, because of the fact that, as things are now, they are living very far away from family and they have some property here, seeking advice on how they want their estate, to devolve according to the provisions of the Sharia. That how can they do it? To do a will that takes cognizance of that. I was so impressed, because this is sort of a modern, you say, a Western Muslim living in the UK, living in London. She works in the city, yet she wants to see that her estate after death, divorce. She could have done any will, but she wants to do it to capture, the faraid. To put everything in place and things like that. So Muslims do this all the time. So it's important.
And I'm gonna come to this topic a little later on about looking at Islamic law in Britain and in its application. Okay. So we'll come to that more. And I wanted to look at the sources as well of Islamic law, Professor. What are the primary sources, agreed upon sources of Islamic law?
Jazakumullahu khaira jaza. Traditionally, if you look at it traditionally, if you look in classical books of Islamic legal theory, the traditional perspective, is that Islamic law has four sources. The Quran, the Sunnah, and the concept of ijma and qiyas. We are talking here about, Sunni classical jurisprudence. We may refer also to the Shia classical jurisprudence. They don't refer to, qiyas, rather, akal. But perhaps maybe you have to concentrate on the Sunni in order to put us online. Now, those are the classical, four sources. Now, over time, you find out that, scholars after evolution, they try to separate what they call the primary sources and then the secondary sources. Now, the primary sources, they limited it to the Quran and the Sunnah. Based on the hadith of the Prophet. And then they consider the secondary sources to be ijma and qiyas. Now, in more recent times, many scholars, including myself, have tried to, be a little more specific, indicating that, the sources, the real sources of the Sharia are the Quran and the Sunnah. Masdaran, that is, there are two main sources. And they see ijma and qiyas more in the sense of, methods, turuq, methods by which we can take the masadir forward. So, and I think it is for clarity, in the sense that a lot of the time, by conflating, saying that, the sources are four, it conflates the divine sources with the, human methods by which we take the divine sources forward. But for the layperson, for us to argue in this way, perhaps maybe this is relevant to those who are learned in Islamic legal theory. Now, for the layperson, even ijma and qiyas will serve as a source for them, because the truth of the matter is, if they ask you a question, I will tell them that, well, this is based on the ijma al-mazahib or ijma of the fuqaha. They just take it. I mean, they don't have any. So for the lay person, one could argue that, well, ijma and qiyas will also serve as a source for them. But these are the four main elements. The Quran and the Sunnah are divine, as we know, but ijma and qiyas, are human methods.
Mhm.
And I mean, you find many of the scholars, and Al-Amidi, for example, indicates, and when he talks about the sources, he indicates clearly that the Quran and the Sunnah is actually what can be called knowledge. Ilm. This is pure knowledge. I mean, but Ijma and Qiyas, they are based on Zan. They are speculative in the sense that, and it's good, especially now, because we are confronted with so many questions. I mean, when people talk about Ijma, you want to push a little bit.
Mm.
Ask, ijma of who? How did they comfort to the ijma? Qiyas, okay, you want to deep a little bit into it. But the Quran, I mean, as long as it's there, find out, yes, this is, I mean, in the Quran. The only areas of difference might be, okay, the interpretations. I mean, especially if the provisions are not qat'i, are not specific.
Yeah.
So, I mean, so those are the four elements of where we look for the law, inshallah.
Okay. And so, Professor, traditionally, when we look at, you mentioned Amidi and other usul books, when we look at them, we are told that these are the tools that are used by the mujtahid, by
Yes.
someone who is qualified to use them, which is a scholar or a qadi. But in today's world, who is that? Is that like you're a barrister, you're a lawyer, you're a judge? Where would that fall in today's language?
Yes, I mean, it's a very relevant debate. Now, in the classical schools, when we talk about, I mean, the concept of, I mean, when we talk about usul al-fiqh, usul al-fiqh, part of it actually is also the debate about, because usul al-fiqh, the heart of it is the element, I mean, the concept of ijtihad, that is, I mean, following the rules in order to be able to extract the law. It is the melting point of, I mean, Islamic law. And part of that, if you look at all the definitions, I mean, they indicate part of usul al-fiqh is determining who is the mujtahid, laying down the qualifications of the mujtahid. And the mujtahid, it's if you look in the classical books, the requirements of being a mujtahid is very onerous. And they classify the mujtahid into categories. We have the mujtahid mutlaq, that is the mujtahid, the absolute mujtahid,
right?
Who, I mean, covers all the ground. He has to be, I mean, al-hafiz. He knows the Quran. Not only knowing the Quran, but he knows all the ayatul ahkam. He knows specific all the ayatul ahkam. He knows all the ahadith relevant as Babu Nuzul, when the verses were revealed, what are they related to? He knows the qat'i, he knows the zanni, he knows the mutashabi, he knows, I mean, all the intricacies.
Right.
Sorry. Now, all the intricacies, I mean, now the argument is, I mean, that when we talk about, I mean, mujtahid mutlaq, today, I mean, it might be difficult to be able to find. I mean, a lot of the time, pointers are to the ai-imma, that is the leaders, the imams of the mazahibs.
Okay.
Like Imam Maliki, Imam Abu Hanifa, and his two students, Shaybani and Abu Yusuf. That I mean, those are the absolute mujtahid.
Okay.
Which perhaps, I mean, one will be cautious to be able to say that, well, anybody meets that qualification at this time. Then, the second category are the mujtahid fil mazhab.
Okay.
That is, a person who is qualified, who has knowledge on a particular school. Do you get the point? I mean, they are very qualified on the methodologies of maybe the Hanafi methodology, maybe the Maliki, and they know it very well.
So mujtahid al-madhhab.
Then there's also, yes, I'm mujtahid fil mazhab. So now the third category, which one could say that, I mean, that second category, a mujtahid, I mean, in relation to a particular school, we could still find some, because they are, I mean, no matter how onerous this is, we still have very established scholars across the world. I don't want to mention names. Now, the lowest at the bottom is, al-mujtahid fil mas'ala, ijtihad yani fil mas'ala. That is, somebody could be a specialist on a particular issue.
Right.
On a single issue in a particular school. For example, issues in relation to fiqh al-usra, for example, says, issues related to family law. Ask me on a particular school, and they are grounded in it. Now we will have a whole lot of scholars in that regard. In all over the world, but it's very, very onerous in relation to, one being able to classify yourself as a mujtahid, but then one has to be conscious of the fact. One of the requirements actually in Islam, Islam requires scholars to be quite humble. You have to be conscious of limitation of your knowledge. You don't want to go beyond that. So these are the three categories, and people know where they put themselves. But to say that they are no longer mujtahidun in the Muslim world will be wrong. There are many of them. So it depends on which category you put them. So that's what I was saying in that regard.
Yeah, very, very interesting. One question that I always have is, so the mujtahid, be he absolute or be he for madhab or be he specific to one field, is qualified to make such a judgment. But one of the other sources of Islamic law is maslaha, is benefit. But sometimes maslaha is determined not just by the mujtahid, but can be determined by a scientist or by a sociologist or by other fields. So what connection is there between the mujtahid and these other fields, and how do we determine the maslaha?
I agree. I agree totally. Now, one would want to talk about maslaha. Maslaha has come to the forefront of usul al-fiqh now in relation to especially, modern usul al-fiqh. Previously, if you look in classical materials, concept of maslaha used to be on the fringes, but now it's coming to the forefront because of the fact that, there's a lot of, because of what's happening across the world, there's a need to emphasize human benefit. Now, when you want to determine human benefit, and the other leg of it is darura, necessity, necessity and human benefit. These two legs, they are determinable, based on the circumstances,
right,
and depends on particular circumstances. Now, for example, if you want to determine the issue in relation to health,
okay,
you find that in the Quran. The Quran states clearly that man kana minkum maridan aw ala safarin. In Faida now, he says that in fasting, any one of you who is ill in fasting. Now, if you look in many of the tafsir, they indicate that, well, how do you determine the type of illness? Because sometimes actually, when you are fasting at the early stage of fasting, if you don't fast regularly, at the early stage of fasting, you feel some headache. It can give you some little bit of headache. It can give you some little bit of stomach rumbling, So, will you say that, well, a slight headache, I'm ill, therefore I will have to, issues in relation to health. Now, many modern jurists indicate that, well, if you have a situation of health, for you to be able to determine a situation of health which will not make you to fast, you might need to consult a Muslim medical doctor who understands health, who knows, who knows about fasting, and is able to determine whether if you go fasting, it can actually deteriorate your situation. It can make you sick. So in such instances, one needs specific advice. And this is why, many of the, contemporary scholars, Mustafa Shalabi, and even Rashid Rida, and in many Muslim majority countries, including Pakistan, they do this, ijtihad jama'i now, whereby, rather than putting the capacity of determining maslaha in the hands of one person, they have, committees of scholars. A person who is very qualified in the Quran will be there. A person who is very qualified in the Hadith will be there. And who also is qualified, in relation to circumstances, modern circumstances. So they will be able to now. So it takes it doesn't lie in the hands of just one single person now, because of the fact that, we live in a very, very complex world.
Yes.
So many countries now practice, this concept of, ijtihad jama'i, that is collective ijtihad. So you can bring many people into the picture. Now, for example, let me give you one. In our community, especially now, many of our youth, because of the availability of the internet and things like that, you are able to reach out to, ulama, even in other countries, in the Middle East and things like that. We have some youth, a couple of youths, they wanted to ask certain questions, and they sent, what do you call it? A message online to one of the big scholars in the Middle East, and it was a very local question they wanted to ask about and things like that. And rightly, the sheikh responded to them. He said, well, the question they are asking is very specific to London, and he doesn't live now. So he advised them, said, go to your local mosque and ask a trusted, alim, a trusted imam who knows the circumstances of your locality, and they will be able to. So it's important to determine maslaha, to do ijtihad. One has to also be aware of the circumstances of particular places.
Yeah, absolutely. And as you said, Professor, that if it's in a council which is contained, then the maslaha will also be done under, the general guidelines of the maqasid of the Sharia.
Maqasid, exactly. Yeah.
It won't be random. You can't, because maslaha is very subjective, but we have to put some kind of framework around maslaha, otherwise it becomes a tool.
I agree. Otherwise it will just become utilitarian, but the truth of the matter is, in some instances, when we talk about, and I do say this, now it depends on the matter. Now, for example, sometimes there could be a person might need to determine a situation that affects them personally. It may not be, a thing that affects everyone, maybe your own personal self. Sometimes, one, your condition better than any other person. And this is where the concept of taqwa comes into the matter. Maslaha is there to be used, but anybody who wants to use those principles, they have to use it with the fear of Allah, because Allah knows our capacity. That's that. If you want to say, the situation of necessity now, darura. You cannot. You have to do it with God consciousness, with taqwa, that you are sincere about it, because Allah knows you. Allah knows your capacity. And you cannot really deceive Allah except anybody who deceives. Allah said nobody can deceive us. Anybody who take this for granted, they are only deceiving their own souls. And these are the guidelines, that actually helps people to be able to take the decision. Even ijtihad that you are talking about, for a mujtahid to be able to give maybe a fatwa or ijtihad on a particular issue, in their mind they will have convinced themselves, they have read the Gaia of examining the sources. You don't just open 2 pages and this is the decision. You have to do the God consciousness, and it is the taqwa that underlines the system that makes it really very vibrant and works.
Yeah, good. Yeah, alhamdulillah. So, one of the qualifications is the person of taqwa, and then obviously that would be qualified further with some worldly qualifications.
Exactly.
Yeah, very good. And so, Professor, that then moves me on to my next point, and that is that we commonly hear in the West, and now actually even in the East, even though the numbers are very small, but the noise they make is quite loud, of like modernists, or maybe even, if I can use the word, secularists. And they talk about reviving Islam or reviving Islamic law. To what extent, when we talk about reviving, can we revive? And I'm talking here purely on the perspective of Islamic legal theory. So, for example, can we revive the sources, right? So you mentioned 4, 2 of them primary. Can we add in 4 or 5? Or can we take some of them out? Is that part of revival? Or would we say we are changing the very foundations of our faith?
Well, as you rightly mentioned, today, because of so many things, particularly modernity, the evolution of modernity, you have a lot of propositions. And, there are those who, in the East, they are called, Ilma Niyun, the secularists. they are there, people who perhaps, I mean, they want to change everything about Islam, including the sources.
Mm.
You know, I mean, the truth, the Prophet ﷺ said it. I mean, before the concept of the Quran and the Sunnah as the primary sources, they have been established. Nobody can take that away. You know, the Prophet said, "Taraktu fikum amrayn." I've left you with "Lan tadillu abada ma tamassaktum bihima."
Mm.
Kitab Allah wa sunnati. I mean, I've left you two things, and you will never go astray as long as you stick to them. You know, the Quran and the Sunnah. I think it will be very difficult, especially mainstream Muslims anywhere. You know, even though many of the secularists are saying this, you know, I mean, the Quran and the Sunnah are the primary sources. They are there. In addition, sometimes interpretations can evolve, can evolve because as knowledge expands, you know, I mean, look, when you take the Quran, believe you me, anytime, and this is why, you know, people don't get tired. I mean, for example, I don't get tired about reading it and going through it. Even though when you read the Quran all the time, you take it, you look at an ayah, you know, so, and you begin to perceive, based on your experiences of, you begin to perceive it in really broader perspectives.
Yeah.
Now you find out, so such as our knowledge expands, our understanding can improve, but we cannot, you know, for example, say that, well, the Quran has played its role, it's no longer a source of Islamic law, or maybe the Sunnah. I mean, the Quran and the Sunnah are constant, you know, I mean, and the others, I mean, ijma. I mean, the concept of ijma, there's this debate of whether ijma can change at all, you know, and this is where it comes. It depends on, I mean, which ijma we are talking about. Now, for example, the ijma of the Sahaba, I mean, it's a higher class, and the Sahaba are gone. They are a very higher class. The Sahaba are gone. The ijma of the Sahaba cannot change again because of the fact that, I mean, that class of individuals are gone. You know, then you have the, I mean, when we talk about, for example, ijma and mazahib, you know, I mean, in that regard, there are some who indicate that, well, in particular mazahib, I mean, depending on experience, I mean, and also new trends in time that can change, and also chaos. You know, chaos is always evolving in relation to, you know, the connecting the illah and things like that. Nobody is saying that, well, especially in relation to meeting the challenges of time, that the fiqh, you know, fiqh Islami is not static.
Yeah.
It evolves over time. The fiqh Islami will evolve over time. I mean, look at, I mean, a whole lot of, I mean, some of even very big scholars like, I mean, Sheikh Qardawi, rahimahullah. I mean, based on changes in time, you know, and using the sources, some of, I mean, changes some of the issues that have been addressed in the past. But when we talk about the Sharia, which is the Quran and the Sunnah, those are constant, you know, but fiqh can evolve over time. So that's, I mean, the part which most of the mainstream Muslims are. You know, even though sometimes the secularists want to run the Quran and the Sunnah down, they are constant. You cannot do that. Definitely.
Yeah, they do have a loud voice though.
They do. I mean, they do. I mean, they have a lot of, I mean, you know, while Halak talks about them in one of his books, talking about the fact that, well, they are very few, but, you know, they have a very loud voice.
Yeah, and Professor, so when we, from a traditional perspective, we have usul, and then we have the furu', and from
Right.
what I'm understanding, that from the furu' we may differ with one another, but with the usul there is really no real disagreement. Is that a correct statement?
Well, I mean, when we talk about, I mean, furu', yes, there could be differences. And actually, you know, what if they are interlinked, what actually creates differences is actually differences from the usul. Do you get it? I mean, what creates the differences in furu' is differences from the usul,
Yes.
because the furu' are established based on, I mean, usul, you know, and sometimes you find out that if you look at the different mazhabs, this is why, I mean, if you look at many of the different mazhabs, now look, for example, now look at the issue of, I mean, mahram.
Okay.
You know, that a woman, from the Maliki perspective, well, the reason why the Malikis differ, and you find traditions supporting each in that regard. I mean, the Malikis, for example, they look at, the concept of Maharam as a protective principle for women, and if you look classical Maliki, materials, looking at it from that perspective, they indicate that, for example, when women travel in groups,
Yes.
when women travel in groups 2 or 3, they don't need a male mahram because they can protect themselves because they are more than one. So, but the Hanbalis don't see it that way. Now, the Hanbalis see it as a strict provision whereby, so based on those differences, you find out that the furu will differ. So to say that, there can be no difference in usul, the point is, and this is, why, the hadith as a source, the use of the hadith, you find out that, the approach, the usul, approach of, interpretation of hadith, the usulul hadith amongst the Malikis differ from the Hanbalis, differs from to the Hanafis. So one needs to, even though we talk about, it's important to be able to appreciate this. Now, as we do discuss in relation to hadith, for example, hadith ahad, solitary hadith, Imam Malik, no matter how strong it is, he believes in them, but he will defer to the actions of the people of Medina, believing that, if the Medina is where the Prophet lived, if the people of Medina are behaving this way from generation to generation, he has confidence in that more than a solitary hadith, solitary tradition. So so this is why perhaps one may not say specifically that in usul there might not be differences. There's agreement on the sources, the Quran and the Sunnah. There's agreement on the methods, that ijma and qiyas, but nitty-gritty sometimes might differ here and there, and this is what affects for all.
Yeah, absolutely. Maybe if I make my question a little bit more clearer, that the usul, as we mentioned, they are generally agreed upon, and then within them, the usage of them may differ. And I think, if I'm correct to say, that it is a matter of tarjih. I don't know what is the English for tarjih, but it is a matter of tarjih. So it's a matter of prioritizing, which is more important than the other. But if I was to say today, 2023, I'm in London and we need a new approach, and I was to come with a new set of sources, right? Would that be considered to be revival, or would that be considered to be heretic and outside of Islamic law?
Well, it's difficult to come up with, any new sources. For every system of law, not only in Islamic law, for every system of law, even in English law, the sources are established. Even though they are not divine, the highest, what we call the grand norm is the Constitution, is the highest. And then others, you cannot bring anything. These are established. So, it would be really, I think it would be really unacceptable anyway for anybody to say that they want to bring any new sources. The sources are established. When we talk, in class we did cover the issue, the concept of modern legal theory, modern usul. You find out that, for it to be acceptable, if you look at, the efforts of, contemporary early scholars like Muhammad Abdul Rashid Rida and all of them, no matter what they are saying, they will still base it on the classical established, and that's the nature of law. Law changes very, very slowly. And Islamic law actually changes more slower. So and that is what makes law. Now, if law can just change, you have a principle of law today, a source of law today. After a month, you want to change it. After it, people, there will be no confidence in it. People cannot have some sort of stability in it. So law, it takes a long time. Every system of law takes a long time. Even customs takes a long time to change. It's a very, very slow moving, and much more even in Islamic law. So, no, I think it will not be acceptable anywhere for anyone today to come to say that, well, people might talk about different approaches in relation to perhaps maybe, scope of interpretation and things like that. But to say that you want to really take the sources away and create a new one. No, I don't think that's possible, really.
Okay, good. So I think then moving on with our discussion then. So in terms of content, I think as we mentioned, there's no changing in that. We may differ with priority, which is more
That's
important.
right.
But then what about in terms of form when it comes to Islamic law? So form and content. What is the discussion around the form and how Islamic law is presented?
Yeah, I mean, that's a very good question. And this relates to, I mean, this concept of taqneen, codification. Classically, um, Islamic law classically was jurist law, whereby, after the Quran and the Sunnah, the Salaf Salihin, the early jurists, they've done a lot of work. And this is why you find that books, if you look at books of fiqh, the Hanafi fiqh, you find going into many volumes, addressing a whole lot of. So, I mean, uh, that's how Islamic law existed classically. That is, I mean, you find issues addressed in books of fiqh. You have to do a lot of research. You are looking for something, you have to really dig deep to find it.
Right.
Now, over time, I mean, yes, over time, and people perhaps, I mean, classical jurists didn't bother with that because it's an interesting thing. They want to, I mean, do the research, look into the materials. But over time, no nation can live in isolation. No nation can live in isolation. I mean, Muslim majority countries rely, especially after the interaction with Western countries, particularly before we came to the Tanzimat, I mean, under the Ottomans in Turkey. You find out that, I mean, during this interaction, the argument was that, I mean, there was a need to have sort of, I mean, the laws, the content of the law presented in a form that is easy to find. For example, if you are looking for something on perhaps maybe divorce, you don't need, maybe if you have a codification where all the rules of divorce are stated, you are just looking for issue on divorce, you can be able to find them. So for a very long time, there was a debate amongst Muslim scholars that, well, is codification permissible? Is it allowed in relation to the content of it? I mean, after a very long debate, there's a general acceptance now that the technique, there's nothing wrong with it. Now, for example, people go back to, I mean, point to many, for example, people talk about it, just about if maybe the early forms of technique under even classical materials. People point to Muwatta Imam Malik, for example. That's indicating that, look, I mean, Muwatta Imam Malik collected a hadith, I mean, in jurisprudential form to make things easier so that to refer to. I mean, Kitab al-Kharraj, for example, of Abu Yusuf. It's only on issue of, I mean, Kharraj. That is, I mean, it's a physical. So many Muslim majority countries today, you find that they have adopted codification. And when you look at, I mean, many of the codified, I mean, laws, they are most of them are classical fiqh that has actually been codified. Personally, I don't see anything wrong in, I mean, codification. The form, might be perhaps maybe alien, might be borrowed, but the content, I think as long as they are still within the Sharia, I don't see anything wrong at all. It's for easy access for us to be able to, especially for people who are not really very deep in Islamic sciences. They don't know where to search for and things. So if you have the codification, it's easy. So I have no problem about it at all. But I mean, but you could still find some few people who will say that, well, codification is a Western thing. Why you cannot codify Islamic law and things like that. But the debate has been beaten.
Yeah, and with regards to the form as well. So if we look at, for example, the way things are done today, judge, jury, barrister, solicitor, and so on and so forth, would that be acceptable in Islamic? Because traditionally, when you look at Islamic books, you think there's a qadi sitting there, two people approach the qadi, and the qadi makes a decision. But in today's system, it's different. You've got lawyers, barristers, you've got a jury, you've got a judge, a high court, lower court. Is that all acceptable in terms of form?
Well, I mean, it depends. I mean, in relation to the issue of, let me talk about the judgeship first. Now, traditionally, you see, things have changed. The world has changed a lot. In essence, traditionally, the judge, the Qadi will sit alone. And sometimes he will have a couple of muftis sitting with them, whereby if there's any issue, they might ask for a fatwa on the issue, then they look at the circumstances and apply it. And the truth of the matter was that the presumption is that, look, at that point in time, I mean, the judges are very sincere. They just want to do justice. Because normally, I mean, people who come before them are lay people. So everything lies, everybody will tell their case, and the judge, will look into it and then perhaps, I mean, give justice. But today, one may say that, well, things have changed to a very large extent. I mean, there's actually, if you look, I think in one of the books, I can't remember, maybe in Tafsiratul Hukam, I can't remember the book vividly, but I used to cite this, I mean, example, whereby, somebody came to, I mean, before a judge and was making his argument. But then, he was not really very articulate in his argument. And the judge advised him, indicating that, I mean, will it not be better for you to get a wakil, get somebody who knows how to present a case, and tell him everything that has happened, so that he can be able to present your case in an eloquent way to us. Because, I mean, there's not, no hakim bi zawahir. We make judgment based on what is presented before us. But the way I'm seeing, you don't know how to present your case. You are just jumbling everything together. And you get the point. So, I mean, people cite that to indicate that, when we talk about, because judges will determine a case, even though the Prophet has said, and this is why the Prophet indicated that, look, you come to me with your cases, and I will only decide based on what you have told me. So if I give a decision to somebody and they know that they are not entitled to it, they should not take it. Because if they take it, they are taking hellfire, they are eating hellfire into their sound hadith. So if you look at it from that point of view, people who talk about representation talk about the fact today that, well, there's nothing wrong. I mean, they put it on the concept of wakala, that is having an agent.
Yes.
There's nothing wrong at all. If you have a case, I'm not eloquent. I don't know how to present my case well. You can get a wakil, a representative. Tell him about all the cases, and he can come to the judge and present it. So you find out that, I mean, in many Muslim majority countries, this is, I mean, what happens. Now, for example, in some of the countries, what differs is that, the concept of wakala, being a wakil in a case, representing somebody in a case, you step fully into their shoes.
Yes.
They will brief you, and then you present the case and do everything. It's not like the Western type whereby they will be questioning and things like that. That person represents fully.
Okay.
The person themselves might be in court, but they will not be allowed to speak because you have given your representative the power to speak on your part. So if one looks at it from that point of view, I mean, times change, and also based on circumstances, one way or the other, these can be accommodated.
Yeah, that could also fall into another principle, Islam principle, is that al-wasail laha ahkam al-maqasid.
Yes, exactly. Yes, that's, I mean, that's really very true. That's a very, I mean, fundamental principle in that, I mean, in that regard. And a lot of people sometimes do not appreciate that, in relation to that. I mean, the means, are just the means to get something done in a proper way. Yeah.
Yeah. Okay. Alhamdulillah. So, Professor, we are coming towards the latter part of our discussion. I wanted to move on now. A few more questions. I wanted to look at Islamic law. It covers all topics. And when we look in the Muslim world, maybe this is my own judgment, but when we look in the Muslim world, I'm going to critique ourselves now, imams and
Yes, good.
When we look at the Islamic world or the Western world, that I tend to see that many of us, we focus much on family law a lot. But law is much broader than family law. What about the other aspects like financial law, administration, criminal law? Where is the revival and the urgency to establish those aspects?
Yeah, I mean, family law usually, it affects the life of people, and therefore, almost all Muslim majority countries that apply Islamic family law today, if you look at it critically, even if they don't call it Islamic family law, their codification, you find that, I mean, it's based on, because it affects, even Turkey, you find out that, I mean, I think in Turkish civil law previously, I don't know whether they have changed it now. If a woman dies, I mean, they say they have gone secular completely. They indicate it in there that if a woman divorces, she cannot marry another man until after 90 days.
Okay.
Is that, yeah, so I used to ask, I said, where did this come from?
Yeah.
You know, what's the basis? I mean, if you look at it, it's the concept of the idda, you know, that they've just, I mean, transferred in there. Or even though they will not call it religious, but anybody who know the system of Islamic law will know that, you know, this is what it is based upon. So family law has always, I mean, been necessary and relevant. As you rightly mentioned, particularly criminal law, I mean, Islamic, I mean, crimes and punishment are so much at the background. And in many colonial jurisdictions, many of the Muslim majority countries who do not apply Islamic criminal law today, those laws used to be there, but they were taken away by the colonial officers. I mean, they had this conception, they call it, I mean, the repugnancy test. You know, all laws that especially criminal law, they will take away, they usually will take away those laws they consider to be repugnant to what that's how they say, repugnant to natural justice, equity, and good conscience. You know, so they say yes. So they say laws that are repugnant to natural justice, equity, and good conscience. I mean, when we were in law school, when I was in law school, I mean, it's not only about Islamic law, even some of the customary laws, you know, of even non-religious, I mean, in countries that were not essentially Islamic. And, you know, we will be making a lot of jest. And there will be a debate. When the European, I mean, colonizer is saying that, well, particular laws are repugnant to natural justice. Like, whose conception of natural justice are we talking about here?
Yeah, exactly.
So whose conception of natural justice, you know? So, I mean, it's really very, I mean, important that one bears that in mind. It is slowly, you know, it's coming back sometimes in a reformed way. For example, in Nigeria in year 2000, about 10 states within the federation, you know, brought back, I mean, the whole Islamic law. Malaysia, Kelantan, you know, some of the Fukan Aceh in Indonesia, some are bringing it back gradually. But I mean, but some are really very hesitant. Amongst all the Muslim majority countries today, I think just about 13 or 14 countries apply Islamic criminal law. All the others, I mean, yes, all the others are putting it at the back burner. Yeah. You know, Islam, another aspect that is coming, as you all know now, is, I mean, Islamic law finance.
Yes.
You know, Islamic law finance is coming back now, even though it also has its own debates about whether, you know, it is being done properly, or perhaps maybe, you know, there's a lot of debate about it in relation to, I mean, there's a lot of heel, you know, around the principles. So there's a lot of challenge in that regard. You know, but I think, I mean, with time, hopefully, you know, one of the arguments in relation to particularly Islamic criminal law, one of the arguments is, if you look at the literature, you know, there are some who argue that, well, okay, many of the countries, many of the societies that are bringing, so it's part of the Sharia, it's part of Islamic law, therefore it must be applied.
Right.
Some of the secularists, for example, are saying that no, it has played its role in the past. So now, I mean, times have gone beyond it. It cannot be applied now. Yeah. Now there are those who are in the middle. Yes, and there are those who are in the middle, you know, who are arguing that, look, Islamic law, the Sharia has to be taken holistically. That, I mean, for the, I mean, the jinayat, for the criminal law to be applicable, it can be applicable only within, you know, a very, what do you call it? I mean, a very well-established society.
Right, right.
You know, a very well-established society. And people do argue that, well, until we have that society, then perhaps maybe there should be a moratorium on it. Right. You know, but those who argue against that indicate that, well, the purpose of the Islamic, I mean, criminal law is actually to establish a stable society.
Exactly.
So it's like a vicious cycle.
Yeah, back to front.
You know?
So Professor, that also brings me to the next thing, especially when it comes to Islamic finance, and we could see that how Muslims are trying to bring about an economical system which is not based on riba interest, when the system in which they work in is the capitalist system, which is based on riba. So it's very difficult. But then also
difficult. It's
yeah.
difficult, yeah.
So that makes me think that there is another aspect of the law which I feel is neglected, or there's not much research being done on it from the Islamic side and from the Western side, and that is a Siasa Shar'iyya.
Yes.
There seems to be a neglect or lack of attention given to this topic, and why is that, and how important is that topic?
Well, I think it's important. I mean, Siasa is important. I mean, in the sense that it's it's for there to be good governance, you know, there has to be Siasa and the executive Siasa, that's exit, whereby, the Ulul has a responsibility to ensure social justice, I mean, economic justice, I mean, taking steps that actually will make society, a very, I mean, prosperous, a society based on Maslaha, based on, I mean, benefits of human beings. Now, also, even in relation to the, I mean, issues of even justice, the concept of Siasa also apply there in that regard.
Mm.
Now, it's really, it depends, in the sense that Siasa has, it is like a double-edged sword.
Okay.
No, so it's a double-edged sword in the hand of the executive.
Uh,
They can use the principle of Siasa to make society better.
right.
But if you have somebody in power who really, they can also use Siasa to actually walk over all the laws.
Mm.
Do you get the point? Arguing that. So I mean, it depends. It's a very good tool. That is part of the principles of Islamic law. But, it depends of who wields it, who is in power. It can be used. Look at the time of, I mean, Umar ibn Abdul Aziz. He did a lot. I mean, he took a lot of steps based on Siyasa actually to make society, a very good society. Those are the golden periods of Islam.
Mm.
So many of them, I mean, if you, they are, in many Muslim majority countries today, you have so many dictators who might do things which is contrary actually to the Sharia. If you ask them, they say they are doing Siyasa.
Yeah.
So I mean, it's sometimes a double-edged sword.
Yeah.
So one needs to be cautious about it as well.
Yeah. كلمة الحق يراد به الباطل.
Yes, sorry.
So yeah, okay, very interesting. Now, Professor, last few questions. Zooming into the UK a little bit more, and we find that there is a pressing need for Sharia courts within the UK. As Muslims, they have lots of issues, and they themselves want to be governed by Islamic law with marriage, finance disputes, and so on and so forth. So, what words of encouragement would you give to those who are willing to try to help people in mosques and other institutions with regards to Islamic law? How important is that on a UK local level? And is it a way of resolving problems and issues within the Muslim community?
Yes, it's important. As we did start, I mean, Muslims are committed to the systems of their belief, and but there have been a lot of debate about it in the UK. And terminologies are very important in the sense that, I mean, where the debate is now is that, I mean, they are not courts.
Yeah.
Those institutions are not called, they don't call themselves courts really. They are called, I mean, Sharia councils. And they do exist in, I mean, in different communities, in different mosques. And the truth of the matter is, I mean, they play a very, very important role. As we say, faith, belief is very, very powerful.
Yeah.
There are some who have a very, very strong belief. No matter what happens, maybe within the family and things like that, which affects them, their belief is so strong that they don't want to go to the civil courts.
Yes.
They want it to be looked at from within the provisions of, I mean, of the Sharia. And this is what these councils are there for. So they serve a good purpose in the sense that, I mean, if they are not allowed, then you find out that those who are very, very committed to their faith in that regard, they will not have access to justice, no matter. They don't want to go to the civil courts, and they'll be so it's important. I mean, particularly in relation to, and they are allowed. It's similar to, I mean, having arbitrators. It's like arbitration. If people agree that, okay, I have an issue with my husband, I have an issue with another person, and I just want to appoint somebody to look into it. Whatever they decide, based on the custom we believe in, we will agree with it. So that's allowed. The only thing is that, I mean, they are not allowed to, I mean, adjudicate or look into issues relating to crimes. They can't do that. They can't look into issues relating to crimes or issues, I mean, that affects perhaps maybe the rights of a third party. and things like that. But if two people, issues that are personal matters, issues like, issues in marriage, now also, even in marriage, one area that usually, there is caution on is, for example, issues of domestic violence.
Okay.
Now, where there's domestic violence is considered to be a crime in this country. Now, for example, if the Sharia councils are looking into a matter of shikak or maybe altercation between a family, and it becomes really very clear, there are clear directives. It's going to become really, very, very clear that domestic violence is involved. Whereby it's very, very clear that serious domestic violence is involved. The police has to be informed. If the police is not informed, the council can get into trouble in relation to the fact that, well, you are encouraging, because domestic violence is a crime in that regard. But they are good in the sense that, and I think, in some mosques, they are there formally. In some, they are more informal, whereby, but you find that, as you know, you're an imam, people will come all the time wanting you to resolve certain things for them. So if you take it away, it will really deny people of a very important service. But one thing is that they are not expected to be called courts. They are councils that look into the affairs of people. So within the community.
Okay, good. So Islamic law is alive and well and much needed.
It is alive, working, and also very, going strong, inshallah.
Okay.
Especially when you live within the Muslim community. You see it in practice.
Absolutely. Professor, if you could just stay with us just for a few moments, and I would just like to share with our viewers our website, the Islamic Literary Society website. You have the homepage there, and you can see our book reviews. So we regularly have book reviews on all different topics: Islamic science, history, politics, poetry, fiction. Yeah, we have lots of different books. So if you jump into history, for example, you will see all these different books that alhamdulillah. So we have a number of people there reading these books and reviewing these books, and they we try to keep them as academic as we can as well. Publications, articles on modern subjects, and then videos. This is where inshallah, Doctor, your video will be uploaded soon. There's also a reading club. There are
a reading club. Okay.
Yeah, so weekly reading clubs, different books, and people come together, read and discuss. And then there is a section for members, those who want exclusive access to inside information, and they could join us there with a very, very small fee, but there's great benefit. So I strongly encourage everyone to, number one, visit our website, and number two, to join the membership as well and take part in this great work. And ultimately, being transparent is the objective of this website, that it is all done for the sake of Allah. It is all done as a charity, and our main goal and aim in this is that we want to shed light on people like Professor Mashood, that we have gems, we have people of real knowledge, of traditional knowledge as well as Western knowledge. These are gems and assets to the Muslim community in this country and in other places, and we want to give them the light that they deserve, so that hopefully through this platform you'll recognize him, you will know him, and hopefully you'll stop phoning him and texting him and you'll be speaking to them more and more often. So this is really our objective of what we're doing. Doctor, I want to really thank you very much for your time, and I know you're very, very busy, and you're going to got a lecture to deliver tomorrow as well. So I want to thank you very much for that. Jazakallah khair, barakallahu fiqh.
Alhamdulillah. Alhamdulillah. Thank you so much for having me. And I'm really inspired by, what you do. I will check the website, inshallah ta'ala, and also consider possible membership, inshallah, down the road.
Mashallah, fantastic. Thank you very much. And dear viewers as well, we want to thank you all for tuning in once again to our podcast, or our interview here. Really, really appreciate all of your contributions and your support, and our viewership is increasing, and the people joining us are also increasing. So we ask Allah Almighty to accept our small efforts in the way in trying to propagate and trying to explain this beautiful religion. We ask Allah to allow us to continue to grow and to flourish. We thank you all for your time, and we thank the professor for his time, and we'll see you with another exclusive video with another book and another author, and you don't want to miss it. So I'll see you all very soon. Thank you very much. Allah bless you all. Assalamu alaikum wa rahmatullahi wa barakatuh.
ليس اليتيم الذي قد مات والده، إن اليتيم يتيم العلم والأدب.